Hi, Richard. So let's have a little bit of a discussion about sexual harassment in the workplace. Can you tell us how that's actually defined from a legal perspective?
Sure. So the chief act that defines sexual harassment is, of course, the Sex Discrimination Act 1984. And of course, there are some recent amendments now in the Fair Work Act which also protects employees from sexual harassment, but the definitions are chiefly taken from the Sex Discrimination Act. And what we're looking at is essentially a three-pronged test of what is sexual harassment. The first test is the conduct has to be sexual in nature. This is, of course, an objective test, so the court has to look at the conduct. The conduct has to be one that is obviously identifiable, and the conduct could be a sexual advance, it could be a request for sexual favours, or the conduct could merely be any conduct of spoken words that is of a sexual nature in and of itself. The second test in any sexual harassment matter is that the conduct must be unwelcomed by the person alleging sexual harassment. Now that's obvious, but it is a statutory test that one must meet. In simple terms, the conduct of a sexual nature must be one that the person did not welcome or found offensive, or found it to be, in simple words, disgusting or offensive in some way. The third test, which is often tricky, is that the conduct has to have happened in which a reasonable person, having regard to all the circumstances of the conduct, would have actually anticipated that the person harassed would be offended, humiliated, or intimidated. And this is, if you like, the context test or the circumstance test. The person that is alleged to have undertaken the sexual harassment, in their own view, must have anticipated that that conduct would have made the other person feel uncomfortable. Often that is sometimes a test that is difficult to meet, sometimes it's easy to meet. It really depends on the conduct in question. My question to you, Ani, is you've obviously answered a lot of phone calls in this particular regard and undertaken a lot of cases. Can you please provide perhaps some practical examples of what we mean by sexual harassment in the workplace?
Yeah, of course. So you mentioned some of them, Richard, the more obvious ones: sexual advances, subjection to sexual material, things like that. But there's also less obvious examples. For example, staring, leering, perving, which are non-verbal conduct. So non-verbal conduct can also be of a sexual nature. And sexual harassment can also be something that's of a sexual nature in someone's presence, but not directly towards them. So, for example, a manager can say to an employee what he did with his wife the night before. And if that's unwelcome, then that's also a less obvious, perhaps, example of sexual harassment.
What about the pornographic poster in the mechanical workshop? Would that be considered sexual harassment?
Absolutely, absolutely. If it's of a sexual nature, as you said before, and unwelcome, it's an individual being subjected to something in the workplace that's sexually explicit and that makes them uncomfortable. And that can definitely also be a form of sexual harassment.
Sure. So I suppose in your experience, is there a fear of people speaking up about sexual harassment in the workplace particularly?
There is, absolutely. There's a fear and often a shame and often confusion about speaking up and what to do in those circumstances. And the solution to speaking up is really, I think, in my experience, having dealt with a lot of these cases, is teamwork. Family support is very, very important. Having the right support in terms of perhaps legal support or medical support, psychological support, all of that's really important in helping people overcome this fear and often shame of speaking up. Just to give you an example, we had a client who the team and I went out to see in the Greater Western Sydney region, close to home. So we actually went to her to make her feel comfortable, with her family around her, to help her to speak up. And she had suffered some very, very vile sexual harassment in the workplace from managers and other employees, and they were both the less obvious and the more obvious types that we've discussed. So staring, leering, perving, also very explicit comments to her, advances towards her and things like that. So we lodged that matter at the Australian Human Rights Commission, and it did take a lot for her to speak up against what she had experienced, but that came with a lot of work from family members, a lot of work from the Connect legal team. A lot of team members were involved.
Sure, because certainly from a legal perspective, one has to prove the sexual harassment. And the first step of that is to get a detailed statement from the victim. And often that's not the work of a lawyer per se, but it's the work of someone who understands what's happened, who's able to empathise, who's able to treat the client with dignity and respect to get that information. And that can be very difficult. Thank you for your time today, Ani.
Thanks very much, Richard.
No worries.
Thanks.